unavoidable delay, supported by the work of the Criminal Justice Inspectorate. In parallel, the two operationally independent bodies, the PPS and the PSNI, were engaged by an independent judiciary in order to find effective solutions. None of this in any way offends the principle of judicial independence. It does, however, represent an entirely appropriate collaboration between the judiciary and others who have an interest in the justice system generally. I meet regularly with representatives of the legal professions, and on the civil side, the judiciary are heavily involved in liaison groups in different areas, and I am committed to developing further our internet resource in order to better inform the public about the nature and extent of what we do. One of the areas which causes greatest public concern is sentencing in criminal cases. Public confidence in the system of sentencing is improved immeasurably if there is transparency in the approach and consistency in the outcome. Last year I set up a sentencing working group, Sean referred to it in his preliminary remarks, which engaged in a consultation exercise with the public to establish those areas where the public felt that there was a need for guidance to promote transparency and consistency. The consultation exercise is now complete, and the public will be in a position to see the benefits of this approach in the next few months. We intend to ensure that the output from this process is readily available on the internet, and that it will therefore contribute substantially to transparency and consistency. I am aware, of course, that the Minister has consulted on a range of options for sentencing, and nothing that we do is intended to replace whatever political decision may be made about the establishment of a Sentencing Guidelines Council. The consultation exercise indicates, however, that there is a cost to the establishment of such a council, and since we already take into account the output from the Sentencing Guidelines Council in England and Wales, the question is whether an additional body here would be value for money. Whatever the outcome of that debate, the work that we are carrying on will in any event be complementary to whatever solution is arrived at. 10 years ago, it may not have been appropriate for the Lord Chief Justice to have given this lecture on this topic. At that time, the head of the judiciary was the Lord Chancellor, and his principal obligations were to appoint new judges, discipline badly behaving judges, secure the independence of the judiciary and speak up for them where appropriate, and reprimand any of his cabinet colleagues who failed to honour that independence. The removal of the Lord Chancellor as head of the judiciary undoubtedly increases transparency, but also calls for a new dynamic between the Chief Justices of each jurisdiction and the relevant executive. It is important for each of those involved in this dialogue to respect the proper field of interest of the other. It is also important that in carrying on the dialogue, all parties are acutely aware of the need to ensure, so far as possible, that public confidence in all aspects of the administration of justice should be maintained. In this evening's lecture, I hope that I have given you some insight into the role of the judiciary in our devolved structures. I also hope that I have succeeded in conveying the message that the judiciary should engage with the community at large in carrying on its work, and is both willing and anxious to do so. The objective for all of us is to build a justice system of which the people in this community can be proud, and which secures widespread support and the confidence of the public. I am absolutely committed to ensuring that the judiciary plays its part in achieving that end. Thank you.
Thank you, Sir Declan, for that. He is advised me that he's quite happy to take any questions from the floor if anybody's prepared or has the courage to ask one. Yes.
You spoke about how you have to evolve the judiciary, but with the world becoming cosmopolitan and the evolved society here in Northern Ireland becoming more cosmopolitan, how would you deal with issues such as Sharia law and what would your personal opinion be?
I'm glad to say that I can, with my hand and my heart, avoid that question. Because under the constitutional arrangements that are in place, I undertake not to express any view at all about matters of policy. So issues of policy, I'm afraid, I will have to leave to one side. Sharia law, I'm afraid, is a matter for the minister. I think I could go so far as to say that he is welcome to it. But you're right about the cosmopolitan nature of our society. We are, I think it's fair to say, struggling a little with how we deal with people from various backgrounds whom we now find involved in the courts of Northern Ireland. We have a considerable expenditure on interpreters for people from Eastern Europe in particular. We have occasional difficulties in actually finding an appropriate language for people particularly from Africa who may have come here and sought asylum where various issues are involved. We, I think, need to be careful to ensure that we respect the traditions of the people involved, because they may have some difficulty in understanding the formality of a common law court system, and we need to be acutely aware of the fact that they are as entitled to a fair hearing, and that a fair hearing means that they've got to be comfortable and understand that that they are getting a chance to put their case and have their case determined in the same way as others. Yes, Anthony.
So Declan, you touched on the on sentencing and on the criticism sometimes by the general public of sentencing. There appears to be a difference in law between England and Wales and Northern Ireland in the context of severe personality disorders as opposed to mental illness. And in some cases this has led to individuals who have been put into the mental health system being released because the mental health system in Northern Ireland, unlike that in England and Wales, has no power to detain them. Is this an issue that has arisen in the training of judges, or do you have any views on it?
Yes, it's actually an issue in which I reflected on in a judgment I gave about 2 to 3 years ago. You're right that the mental health legislation in this jurisdiction does not include those with a personality disorder as being people who are subject to the defined forms of mental illness. And the reasoning behind that is that the mental illnesses which are described within the, I think it's the 1986 Mental Health Order, are those which are treatable. And the argument is that a personality disorder is not a treatable illness and therefore should not be characterised as a mental health disorder. England and Wales take a different view. And the practical effect of what happens is that it's not unusual to find those with personality disorders coming before the courts. I suspect there's probably a considerably greater proportion of people with disorders who actually come before the courts than the general public. And some come before the courts in relation to extremely serious crimes where there is a high likelihood of danger of repetition. Where a mental health disorder is involved, the disposal will certainly involve consideration of what's called a hospital order with restriction. In other words, a hospital order where the patient will be treated and where there will be continuing supervision of the issue of whether or not it is safe to release them, and that may go on for a very long time indeed. But I dealt about 2 to 3 years ago with a case involving somebody with a personality disorder who had committed, I think, a murder, and the issue was whether or not that person, for various reasons, should be subject to a hospital order. And I concluded that in light of the risks, and because of the issue that you had described, that the appropriate sentence in that case was a sentence of life imprisonment. And I know that one other colleague of mine has touched in this area in the same way too. One of the difficulties about hospital orders in this area also arises because of our lack of resource. We do not have a secure mental health facility in Northern Ireland. We have a medium secure facility up at Knockbracken, the Shannon Clinic, but we do not have a secure mental health facility. So if you have somebody who suffers, say, from paranoid schizophrenia, in respect of whom a hospital order may be made, that person will generally be transferred to Carstairs in Scotland, where they will undergo their treatment. And of course, the problem is that their opportunity to stay engaged with their family is diminished, and that inevitably has an effect upon the likelihood of rehabilitation, because generally rehabilitation for somebody with that kind of illness is to be secured. It will generally involve some form of family supervision, in particular of their medication. Yep. Yes?
I just wanted to tackle, you mentioned communities a lot in your talk. And to what extent is the judiciary there to protect us from ourselves in the sense of delivering justice as opposed to vengeance?
Well, I said that there is a balance that needs to be struck. I saw the Supreme Court programmes that were published recently. One that seemed to be about what you give your wife for breakfast, and the other seemed to be a relatively serious programme about what the work of the Supreme Court was. But what worried me a little about the way in which the programme was developed was that the senior president of the Supreme Court, Lord Phillips, appeared to suggest that the courts were there to protect individuals from the abuse of power by the state. And I don't accept that that is what the courts are there for. The courts are there in cases where it's necessary to do it, to effect the proper balance between the rights of the individual and the rights of the state, or the rights of the community. There are cases, and you're undoubtedly right, where there are difficult decisions to make. For instance, we were talking before we came down here this evening about a new offence which has come onto the statute book within the last 18 months, 2 years or so, and it's the offence of careless driving causing death. That's an offence which was never on the statute book before. Careless driving involves a potentially very modest degree of culpability indeed, can be momentary inattention of the most common sort, and yet if the consequence from that very low culpability is death, potentially there is a prison sentence of up to 5 years awaiting the person who's responsible. Now, I actually did a guideline judgment in this about 9 months ago, which indicated that for the momentary inattention, that case would probably lie in the non-custodial sphere. But it is an indication of the tension that arises between culpability on one side and harm or consequence on the other. And there's no doubt that there has been a shift, certainly in the thinking of the executive and the legislature, so as to promote stiffer sentence where there are unfortunate consequences, even where culpability might well have been modest. It's fair to say that another example, I'm not going to talk about individual cases. I'm certainly not going to talk about any of the cases about which there's a discussion going on at the moment. But in this jurisdiction, we changed the approach about 3 years ago, 2 to 3 years ago, the approach which we take to what are called single punch manslaughter cases. There are many instances, and the lawyers here, I'm sure, on the criminal side will be familiar with them, where people for various reasons get into a row about something or other, and there's a push or a punch or whatever it may be, and in virtually all of those instances nothing happens, everybody walks away, the police are never involved, it's a complete non-event. But every now and then something awful happens. The person who's pushed falls back, their head strikes the ground, they sustain a serious injury and die. And the question then is, how do you deal with that kind of situation, where somebody perhaps rashly, on the spur of the moment, did something which they shouldn't have done, and the consequence is that often a young life is lost. The English cases which were followed in this jurisdiction until about 2 to 3 years ago suggested that the starting point was probably a sentence of about 12 months imprisonment, and if there were particular extenuating factors, that sentence might be suspended, and if there were any aggravating factors, then it might be increased. And I know when I pass sentences, I can think of one in relation to a case of that kind, that was the guidance or guideline upon which I operated. But the courts changed the guidance in light of public concern about this issue, and the starting point in a contested case is now somewhere between 2 and 4 years imprisonment. So it's a fairly considerable stiff increase to reflect consequence. The culpability in these cases, as I say, for the reasons that I've given, may be quite modest, but it's the consequence that that the community has decided should be reflected. And that's your point about the individual rights of the accused and the rights of the public, the protection of the rights and freedoms of members of the public. Because in the end, members of the public shouldn't be pushed or punched by people who maybe had a few drinks on a Friday night. And it's important that people feel protected where such conduct takes place. Yes, Ian?
Just by an extension on that, where does the victim impact statement sit, and where should it sit in the judge's guidance, and how you...
Yeah, two things. The essential matters that one needs to look at when engaging in sentencing is, one, to look at culpability, and two, to look at harm, the harm caused, and three, to look at the potential impact for the public, depending upon your sentence. So if you've got somebody who's a predilection to carrying out a certain type of crime, you need to remember that you've got to pass a sentence which is going to be sufficiently protective of what the public is. But when you come to the question of harm, therefore, it's entirely appropriate to look at what harm this case has caused to this victim. And in fact, I go further. I have met some of the members of the Community Safety Forum of the West Belfast Community Safety Forum group to discuss with them the question of community impact statements, because within communities, certain types of crime may give rise to particular concerns. For instance, if groups of pensioners are being subject on a regular basis to what might be thought a nuisance crime, or worse, burglary or something of that kind, which causes them concern, the courts need to know that. And there needs to be, somebody needs to apply their minds to a process which ensures that the courts are aware of the fact that these victims living within this community, or people living within this community, are affected by the crime that's taking place. The courts need to factor that in. They need to take into account that there has been that harm caused. And in the way that I've described, then that will be an aggravating factor if it is significant harm, which ought properly to justify an increased sentence if an increased sentence is appropriate in a particular case. So harm and the role of the victim is an important consideration, and in virtually every case that of any seriousness, certainly you will see a victim impact statement, or the victim will have decided not to provide one. Yes?
Sir Declan, I wonder, can you say anything about legacy cases which have come about as a result of the Troubles, in particular involving Greece? What I'm interested in is alternatives to judicial settlements, or punitive settlements. Is there any, do you see any ground, any way that those cases can be resolved outside the law?
I'll choose my words carefully in this area. I have a particular concern about legacy cases for purely administrative reasons, because there are a lot of cases, about 30 cases, involving old incidents where families have been pressing for inquests or hearings for a long time and are entitled to have a proper hearing in relation to the circumstances surrounding the death. The conduct of those inquests inevitably takes, because of the controversy associated with many of them, inevitably takes a considerable amount of time and involves the consideration of a very wide range of documents, and you find that they tend to be reasonably complex cases, creating all sorts of legal issues. Doing the 30 cases looks to me as though it might take 5 years, assuming that everything gets started reasonably promptly. And the first of those cases is listed for hearing on the 3rd of October, later this year. Whether there's an alternative, I think, is probably a wider question. And the wider question is about how, as a community, we choose to deal with the past. There have been, as we all know, attempts to consider how we might achieve that. I don't think anybody has a solution yet. I honestly would have been surprised if a solution were achieved prior to the new assembly being put in place. It may be that one of the tasks for the new assembly will be to start thinking about how they might do that. I think the other, as it were, undercurrent of your question is, does the legal system necessarily afford the kind of satisfaction to those who are looking for answers and looking for explanations as it should? And certainly where the legal system takes the sort of time that has been taken in relation to these cases, one has considerable doubts about that, albeit that I'm conscious, that having appeared for 2 of those who were injured in the Bloody Sunday case, that there was an enormous sense of vindication among those who were the victims of that particular incident, even though that case took as long as it did to come to a final determination. Yes?
Declan, given that over the last decade there's been a proliferation of the number of offences created, and most of this come from Westminster legislation, is there a concern at a judicial level that A, some of the legislation become much more draconian, and B, some of the powers that were in previous legislation given to the judiciary, some leeway have been removed by such legislation?
Well, the question of whether or not the sentences have become, or the legislation has become more draconian, is a matter entirely for the Minister, Jerry, so and therefore I feel entirely comfortable about choosing not to answer it. I'm not sure, in truth, that the judiciary in Northern Ireland have yet experienced a diminution in the amount of discretion that they have in relation to sentencing. I mean, I accept that there is some pressure for an upward lift in some areas, but generally, if one looks at the sentencing structures, there are not yet in place structures which impose a straitjacket on sentencers. There are proposals to do that. I mean, some of the proposals would suggest that if we have, for instance, a sentencing guidelines council, that a judge would have to sentence in accordance with the guidelines, perhaps giving, if he was sentencing, he or she sentencing outside, giving some reasons for doing so. But one needs to be careful about a sentencing guidelines council, because the more prescriptive you get, then the less wriggle room there is to do the right thing in particular cases. And sometimes the right thing is to go well beyond the guideline to recognise the harm that has been caused and the enormous culpability of the person who has been involved. And sometimes the right thing to do is to exercise leniency or mercy in a particular case. And my concern about guidelines is that there is sufficient room left within them to ensure that in the right case, in circumstances that have never been contemplated by those who are preparing the Sentencing Guidelines Council, that the right balance is struck between the interest of the individual and the interest of the community. Yes, Jerry.
I wonder, I'm very interested in, and indeed would endorse your comments in relation to the press, and then comments in relation to the difference now that there is a Justice Minister, in particular the Justice Committee. I'm just wondering, I wouldn't expect or want you to comment on any current cases that are perhaps in the media, but is there a danger that the Justice Committee could end up scrutinising individual judicial decisions as opposed to the judicial policy, establishing policy, or monitoring the minister?
Well, if they read my speech, they won't, Jerry.
Well, actually, that means I was wondering,
that
because
sense is the short answer to the question.
well, that was the reason it was asked. I'm just wondering in that regard. We have a very young assembly, and therefore it is possibly expecting too much for some of the representatives to understand the intricacies of this. And I'm wondering, is there any process by which you or others can indeed help the learning of the assembly?
Well, one of the ways is by giving 3 lectures in the space of 2 weeks, which is what I'm doing at the moment, because I'm also giving the Chancellor's lecture at the University of Ulster tomorrow, and the Prioress's lecture in 2 weeks' time at St Dominic's in West Belfast. And on each occasion, I will take the opportunity in various different ways to make the point about what is the territory that is reserved to the judiciary and what is the territory that is reserved to the Assembly and the Executive, and to make it plain that as a judiciary we entirely respect the area that is reserved to the legislature in particular. If they don't like our decisions, they can make new laws, and in the end, that's what they have. But you're right. The reason that I'm embarking on this particular series of lectures on this particular topic at this time when the Assembly is just over, and before we get into the election campaign, and therefore the time when people can start to think about these things, is to get on the record the importance of ensuring that the Justice Committee, who are new to the job, they haven't managed a full year, they're new to the job, that the Justice Committee understands where the boundary is. Now, although I wouldn't want it overly widely reported, the Attorney General is actually going to have a conference towards the end of June on the topic of judicial independence, at which I will be speaking. And the audience, I think, will be those who need to hear the message. Yes?
Mr. Declan, what's your view in relation to the lack of women sitting in the higher echelons of the judiciary?
I'm horrified for all sorts of reasons, but I'll perhaps give you some thoughts in relation to that. First, as chairman of the Judicial Appointments Commission, the overriding commitment of the Judicial Appointments Commission is to appoint on merit. And we have a commission which is roughly 50-50 lay people and judges. We have extremely experienced personnel, people who sit as part of the commission, and we spend a lot of time seeking to ensure that we do our bit for diversity. And we have had a measure of success. I can't give you the figures offhand, but if you look, for instance, at the number of district judges, you will find that in recent appointments that there has been something pretty close to equality in terms of men and women. If you look at the number of county court judges, out of the 17 county court judges, we now have 5 women, which is a considerable increase on where we are. Your question, I think, was directed at the fact that although we have 14 judges in the High Court and Court of Appeal, we don't have a woman there at all. part of that is a reflection of history. When I was called to the bar, there were 19 of us, of whom 3 were women, and of those 3, I think 1 is still in practice. And therefore the pool of women who are actually ready